Hi, my name is Amanda Rocha. I'm an estate planning and probate attorney in California, and today we are going to talk about what documents you need once you've had a baby. Before I get into that, I want to give you my contact information. You can find me on my website at www.amandarocalaw.com. You can comment down below, as always, if this platform allows you to do that, or you can follow me along on social media at Amanda Rocha Law. So the reason I want to talk to you about this today is because there seems to be an influx of people contacting me who are either pregnant or who have recently become a parent. And they want to know, now that this has happened or is in the process of happening, what do I need to do to make sure that my child is set up and protected and that I am protected as well? It's really the biggest trigger of estate planning for most families. And as most of my clients tend to be young families, I deal with this quite often. So just to jump right into it, the very most important document that any parent should have if they have children that are under the age of 18 is a declaration of guardian. This is a separate document outside of a will that is just a standalone legal document wherein you name guardians to take over in the event of your incapacity or death. They could be the same people or they could be different for each situation. And basically, it's a document that you name someone to take over immediately, someone to as a backup, and you can even name multiple backups if you want to. The benefit of having this as opposed to solely naming a guardian in your will is that your will is only effective once you've passed away. If you do not pass away, then what you write in your will doesn't matter. So if you become incapacitated, this document can be used to quickly transfer your child into the guardianship of the person of your choosing, as opposed to a court process happening and a judge having to make a decision based on things that you write down on paper and not based on whether or not your child has a relationship with this person or you personally trust them, or any other reason which you would choose someone as a guardian for your child. So that is the number one most important document I think every parent should have. The good news about this document is that it does not have to be notarized or witnessed. So you can create this document quickly if need be. The next most important thing that I think every parent should have is protection for themselves for health care. I know, and we all know, that everyone will eventually pass away. So yes, a will is going to be necessary for everyone, right? A trust will be necessary for many. And in California, a trust is going to be necessary for a majority. However, what we want to do is make sure that once we become incapacitated, whether it's due to a disease or an accident or whatever it possibly could be, that we are taken care of so that our children could be taken care of as well. So you already have the guardian declaration in effect, but you'll want to have somebody acting as your healthcare power of attorney and your financial power of attorney so that your life can continue moving forward while you are unable to make that happen. So if you have dependents or if you have minor children, rent can continue to be paid on your properties or mortgage or whatever, so that when you become capacitated again, fully capacitated, then you and your children can go back to living life, as opposed to then having to figure out moving and all the other things. So it's important that you have these documents in place so that you can be cared for, so that when you are able to care for them again, it isn't a major battle. And then of course you should have a will. Everyone over the age of 18 should have a will, regardless of whether they have children. Having children is just another reason to have a will, especially if you're not married to your child's other parent. It's important to have a will, and if you have a trust, it even gives you even more possibilities of holding property for your children until they're the age that you choose, as opposed to just at 18, which is the age of majority in California. So you can basically choose the trustee and the person who will be in charge of whatever property you want, whether that's money or real property or whatever it is, until the age that you determine your child might be ready for it. So call me. Let's talk about it. If you're in California, I'm your girl. This is what I do every day. We can not only prevent probate, but we can set up your children to where they don't have to basically miss out because you didn't fill out a few documents. You can find me on my website and schedule an appointment through my contact page. You can find me at www.amandarochala.com. You can comment down below if this platform allows you to do so, or find me on social media at Amanda Rocha Law. Thank you.